Thank you all for having me here today. Wonderful to be with you. When we think about the history of the Israeli-Palestinian conflict, or even the situation today with the Israelis and the Palestinians, the law is usually not the first thing that leaps to your mind, right? But some of you may say, well, wait a minute, Zipperstein, what about the International Court of Justice, which just got a referral from the UN General Assembly to issue an advisory ruling on the legality of the occupation? What about the International Criminal Court? And sure, that's going on right now, and we can talk about that a little bit later. But if you look back over the last 100 years, remember that after World War I, Britain came in. The League of Nations appointed Britain as the mandatory. We had the Palestine Mandate. During those years, the 1920s, 30s, and 40s, the Arabs and the Jews made extensive use of the law. There were multiple trials between the parties during those years. And I think it's fair to say that the Arab-Jewish conflict during the British era was as much a conflict that was fought in the courtroom as it was fought in the streets. And we're going to talk today about 4 of those trials, those legal proceedings that played out in the last decade of the Palestine Mandate between, I start here at 1939, but we're actually going to start with 1937 and 1948, when Israel's Declaration of Independence was read by Ben-Gurion. We'll see a photograph of that in a few minutes. And these 4 trials that I have up here on this slide, in a 10-year, even less than a 10-year period, produced 3 different outcomes. The one-state solution in May of 1939, one state in favor of the Palestinian Arabs. We'll talk about that. Then after World War II, the Anglo-American Committee came up with the no-state solution. No state for the Jews, no state for the Arabs. In fact, Britain or the United States would continue to rule over Palestine indefinitely. And then in 1947, in 2 separate trials, the United Nations came up with the 2-state solution. So we'll talk about how we went from one state to no state to 2 states during those years as a result of these trials, these judicial proceedings. But before I take you to London in 1939, I want to go back to Jerusalem, 1937. The King of England decided, and remember we had the Arab uprising during 1936 to 1939. The King of England decided, before he abdicated, Edward VIII, to send a very prestigious royal commission to Palestine to conduct a trial, to hear testimony from Arabs and Jews, and to render a verdict about the future of Palestine. And here you see the members of the Palestine Royal Commission, led there third from the left by Lord Robert Peel. This became known as the Peel, P-E-E-L Commission. You see them there photographed in Jerusalem in 1937. And after hearing months of testimony, both in public and in secret, the Peel Commission proposed the original version of the 2-state solution. On the left side of the screen, you see their report from July 1937. On the right side, their map of what they envisioned would be a 2-state solution. The orange area in the upper left, small portion for the Jews. The purple, the vast majority of the area for the Arabs. And Britain, of course, would keep for itself in perpetuity the area in green connecting Jaffa to Jerusalem and Bethlehem. Well, the British government decided to send a commission, a follow-on commission to Palestine in 1938 to determine how to implement the details and the mechanics of this 2-state solution. And while that commission, called the Woodhead Commission, were undertaking their investigations in Palestine, war rumors and war stirrings began to brew with Germany. Germany, of course, had annexed Austria in March of 1938. And in September of 1938, Prime Minister Neville Chamberlain traveled to Munich and signed the infamous deal with Hitler. You see Chamberlain on his return to the UK that day, waving the paper. You've all seen this, the grainy black and white video. "We will have peace in our time," proclaimed Prime Minister Neville Chamberlain. Why? Because he made a deal with Hitler under which Hitler would be free to take over the western part of Czechoslovakia, the Sudeten region, ethnically German predominantly, in exchange for which Hitler would not invade France or Britain or Poland or any other of Britain's allies. At that same time that this deal was made with Hitler, the Woodhead Commission in Palestine finished their work, and on November the 9th, 1938, the exact same day as Kristallnacht, the Woodhead Commission said, you know what, to the British government, the two-state solution is not practical. It'll never work. In fact, what was going on with Kristallnacht and with you see a Jewish business destroyed, a Jewish synagogue destroyed, was that the British government was having very, very, very serious second thoughts about the deal they had just made with Hitler. The British government realized by late 1938 that war with Germany was very, very likely inevitable. And when that war came, Britain wanted to make sure to keep the Arabs and the Muslims in the Middle East, and especially India. Remember, India is still a British colony with a huge Muslim population. Greater than all of the Arab countries combined were the Muslims in India. Britain wanted to make sure that when that war came with Germany, that the Arabs and the Muslims in the Middle East would stay on Britain's side. After all, Britain, Lawrence of Arabia, had convinced the Arabs to switch sides in World War I. They didn't want Germany to do the same thing to them in World War II. We'll talk about that more in a second. And so here you see the British colonial secretary, Malcolm MacDonald, son of the former Prime Minister Ramsay MacDonald. And in December of 1938, Malcolm MacDonald went to the British cabinet, to Prime Minister Chamberlain, and said, we should bring the Arabs and the Jews here to London early next year, early 1939. Let's have a conference. Let's see if we can get both sides to agree on a settlement of their disputes in Palestine. But very likely, they won't be able to agree. And when that happens, we need to impose our own solution on the parties. And the cabinet agreed, and the government invited the Arabs and Jews to come to London. This is St. James's Palace, February 7, 1939, for the opening ceremony of the Jewish-British Conference. You see Prime Minister Chamberlain. I can't use my pointer here because of the television monitor. The Prime Minister Chamberlain in the back with the mustache, flanked by Malcolm MacDonald to his left, who I just showed you, and to his right, Lord Halifax, the foreign minister at the time. This is the opening ceremony. Who do you not see in this photograph? No Jews. Not just Begin, no Jews in this photograph. Here is Jamal Husseini, cousin of the notorious Grand Mufti of Jerusalem, Haj Amin al-Husseini, the leader of the Arab delegation. This is his lawyer, Auni Bey Abdul-Hadi. This is George Antonius, who we'll talk about more in a second. The Arabs refused to sit in the same room as the Jews, and so 2 hours after this opening ceremony, the Prime Minister of the United Kingdom had to do another opening ceremony with the Jews, because the Arabs refused to sit together with them. And so here you see David Ben-Gurion, future first Prime Minister, Chaim Weizmann. Anybody know who this is for extra credit? Who said Sharet? Very good, A+. Second Prime Minister of Israel after Ben-Gurion. And so imagine the humiliation for the British government to have two opening ceremonies on their own turf at St. James's Palace. Well, I mentioned George Antonius, Christian Arab, who in late 1938, just a couple of months before this conference began, wrote this book that you see here, very famous book, The Arab Awakening. And in the appendix to the book, Antonius went back to World War I before the Balfour Declaration, and he published, for the first time ever, the series of letters that went back and forth between the British ambassador in Cairo, you'll see him in a minute, if I still have his picture, Sir Henry McMahon, and the leader of the Arabs in what was then called the Hejaz, what we today call Saudi Arabia, the Sharif Hussein of Mecca, in which the British government enticed the Arabs to switch sides, rise up against Turkey. You've all seen Lawrence of Arabia, rise up against Turkey and fight alongside Britain in World War I. What was the price that was demanded for that switching sides? We'll talk about that in a minute. And so Antonius published these letters, and very quickly, the Arabs who had come to London said, you know what, we need to have a trial on the issue of whether or not Britain promised Palestine exclusively to the Arabs in World War I. And the Arab case was based on this series of letters that had been published, most especially this letter from October 24, 1915, in which Sir Henry McMahon, the British ambassador, wrote to the Sharif Hussein in Mecca. By the way, if I didn't say this before, let me say it again. The Sharif Hussein of Mecca in 1915, future great-great-grandfather of the current king of Jordan, King Abdullah II. So you understand the lineage. And in this letter, the British ambassador in Cairo said, yeah, if you switch sides, rise up against Turkey, who had been your rulers for the last 4 centuries, 1517 onward, fight alongside Britain, become our ally, we will promise you your independence in the Middle East. Except for 2 things. We cannot make promises to you in those areas of land where our ally France has an interest. Meaning what? Lebanon, Maronite Christians and Catholics, meaning Jerusalem. Nor can we say that areas lying to the west of the 4 main towns in Syria, Hama, Homs, Aleppo, Damascus, areas lying to the west of those 4 towns are not exclusively Arab. Well, if you look at the map, the area to the west of those 4 towns is Lebanon, not Palestine. And so for the last 108 years, including today, in the International Court of Justice, the Arabs say Palestine was promised to us. Britain pledged Palestine to us to entice us to become their ally in World War I. Well, 2 years and 1 month after that October 1915 letter, Britain promised Palestine to somebody else, didn't they? To us, in the Balfour Declaration, November 2nd, 1917. His Majesty's government view with favor the establishment in Palestine of a national home for the Jewish people. Okay, it's a little ambiguous. What does in Palestine mean? In all of Palestine? In part of Palestine? What does a national home mean? A country, a beautiful JCC like you have here. So ever since then, for the last 106 years, the Jews have maintained that Britain promised Palestine to us. The Arabs have said no. Britain first promised Palestine to the Arabs 2 years earlier. Well, the League of Nations, which was formed after World War I, remember the Treaty of Versailles, World War I would be the war to end all wars. This international organization called the League of Nations, the predecessor to the UN, is formed. And the League of Nations divided up the territories that the victorious powers in World War I conquered from Germany and Turkey, divided those up between Britain and France primarily, putting Britain in charge of Iraq and of course Palestine. France got Lebanon and Syria, and those territories were conferred temporarily on Britain and France, who would stay there and provide tutelage to the local population until they were ready to become independent, to become autonomous. But the Palestine mandate is different from all those other mandates. Why is this mandate different from all other mandates, we might ask right after Pesach? Because this mandate incorporated by reference the pledge of Britain to the Jews in the Balfour Declaration. It completely ignored the prior British pledges to the Arabs. The mandate says in its preamble, whereas recognition has been given to the historical connection of the Jewish people with Palestine and to the grounds for reconstituting their national home in that country. The Balfour Declaration says establishment of. Chaim Weizmann lobbied the British government as hard as he could to say re-establishment, not establishment, because if it's re-establishment, then you're not a colonist. You're not taking over somebody's land. You're coming back to that which was originally yours. And although Britain refused to write re-establishment, Weizmann continued, and he scored huge success at Versailles and at San Remo when he convinced the League of Nations to put that word reconstituting in the mandate, which became part of international law. It was approved unanimously by the Council of the League of Nations on July 24th, 1922. We just celebrated the 100th anniversary last summer. And just to rack up for you, what are the relative rights and obligations conferred by the mandate? Well, the Jews received all of the political rights. None were conferred on the Arabs. The only right that was conferred on the Arabs, but not the Jews, was the right to control the purely Muslim sacred shrines in the country. And so today, when the Arabs get very upset when Jews go up to the Temple Mount to pray, the Arabs trace the legality of their position to this document right here, to the mandate. But you can't have it both ways. If you invoke the mandate to keep Jews off the Temple Mount, then you have to also realize that the mandate did not confer any political rights on the Arabs, only conferred on the Jews, including, very importantly, the right to immigration and the right to purchase and settle on the land. Well, at that conference in London in 1939, February, March 1939, the Arabs, as I said, wanted to have a kind of a mini trial on the issue whether or not Britain had promised Palestine in World War I to the Arabs. The British government agreed. The British government appointed their Lord Chancellor, the equivalent of the Chief Justice, to be their lawyer. The Arabs hired the former British Chief Justice of Palestine, Sir Michael Macdonald, and for 3 weeks, both sides presented their case to each other. They ended up not agreeing, and the larger conference, this sort of shuttle diplomacy that the British were conducting with the Arabs and the Jews, because the Arabs refused to sit together with the Jews, that conference collapsed also on March the 15th, 1939, the exact same day that Hitler broke his promise to Chamberlain and invaded Prague. To me, this is really the start of World War II, not the later invasion of Poland on September the 1st. When Hitler broke his promise to Chamberlain, tore up the agreement they had made just a few months earlier in September, that to me was the official start of World War II. Now, who would have been watching developments in Prague and Czechoslovakia with great concern? Which neighboring country of Czechoslovakia had at that time the largest Jewish population in the world? Poland. And 2 days after those German troops marched into Prague, on the 17th of March, 1939, and I found this in Prime Minister Chamberlain's files in the British National Archives in London a couple of years ago, 3 years ago. The Polish Jewish community sent this desperate telegram to Prime Minister Chamberlain. And if you permit me, I'd like to read it to you. To the Prime Minister, London. In the darkest and most tragic hours of history and life of Jewry, 3.5 million Jews in Poland appeal to His Majesty's government, the authority which has undertaken responsibility to create a seat in Palestine for the Jewish people. We appeal to His Majesty's government to consider both the confidence which the Jewish people have placed in England and the most sacred hopes of Jewry, and not to apply a policy in Palestine which throws the Jewish masses into an abyss of despair. Signed by the United Zionist Organization of Poland and Agudat or Agudas Israel of Poland. When I saw this telegram, was obviously quite shaken. I spent the next 3 weeks in the archives looking for any evidence of any British response to the Jewish community in Poland, and there is none. I checked with Yad Vashem, I checked with the US Holocaust Memorial Museum, I checked with the top professors around the world regarding Polish Jewry in the war. None of them had ever heard of this telegram, and all of them confirmed that there was never any evidence of a British response to this telegram. When the war ended, there were not 3.5 million Jews left in Poland, there were 75,000, and almost no children. Now, why did that happen? Because, as I said earlier, the Colonial Secretary, Malcolm Macdonald, had told the cabinet in late 1938, we'll invite the Jews and the Arabs. If they can't agree, which they probably won't be able to, we'll impose our own solution. And that solution became known as the White Paper of May 1939, the notorious White Paper. And I found this document in the archives as well. This is Malcolm Macdonald's original handwritten draft in his own handwriting at his country home in Great Waltham, Essex, Hyde Hall. He went for the weekend and wrote in his own handwriting the first draft of what became this: the Palestine Statement of Policy, the MacDonald White Paper of May 17th, 1939, which did three things. Number one, it severely limited the ability of Jews now trapped by Hitler to leave Europe and go to Palestine, capping immigration at a grand total of 75,000 over the next 5 years between 1939 and 1944. By the way, when the war ended, that 75,000 quota had not even been used. About 72,000 had been able to escape. Now, why would Britain do that? Remember I said they wanted to keep the Arabs, the Muslims in India on their side as war was approaching, clearly trying to curry favor with the Arabs. But what about that provision in the mandate I showed you that Britain had to allow immigration to Palestine? They ignored it by imposing this very severe limitation. The main reason for the immigration limitation was that Britain wanted to lock in a 2-to-1 Arab to Jewish majority in Palestine. Because the white paper also said, and this is the part of the white paper that everybody forgets, the white paper said, after 10 years, in 1949, Britain will lower our flag, will leave Palestine, and it will become a single state. The one-state solution under majority rule, meaning what? A Palestinian Arab state. And during the interim, Jews can't buy any more land. Well, the Jewish delegation were crushed by this. Weizmann wrote an angry note to the Prime Minister and the Colonial Secretary saying, you've just condemned the 7 million Jews in Europe to their slaughter. And you would think that the Palestinians would have leaped at this offer. This was, not to quote former President Trump, but this was the deal of the century for the Palestinians in the 20th century. The Mufti said, no deal. 75,000 more Jews is 75,000 too many. I don't want a single additional Jew allowed into Palestine. And 10 years is too long to wait for our independence. I want it now. All or nothing, which became a recurrent theme and is still a theme today, unfortunately, of Palestinian diplomacy. Well, the war came later in 1939 and lasted until, as we know, 1945. And on Valentine's Day, 1945, after leaving the Yalta Conference, President Roosevelt boarded a U.S. naval vessel called the USS Quincy, sailed through the Suez Canal into the Great Bitter Lake, and met for the first time with King Ibn Saud of Saudi Arabia. This was the famous meeting that established the long-running, although now somewhat shaky, United States-Saudi relationship. You give us oil, you let us have overflight rights over your territory, and we'll give you the protective umbrella of the United States military. The person kneeling to the right of the king is United States Army Colonel William Eddy, a fluent Arabic speaker who served as translator and later became the first US ambassador to Saudi Arabia. Roosevelt gave the king a gift at that meeting, a Douglas DC-3 airplane, a Dakota, and there was a swivel throne-like chair in the plane so the king could always see Mecca no matter where the plane was. 2 months to the day later, in April 1945, President Roosevelt passed away, and Vice President Truman became the President of the United States. And many of you may remember that at his haberdashery in Independence, Missouri, then Harry Truman, before he went into politics, had a business partner who was a Jew, Eddie Jacobson. And the Jewish community and the Zionists had a little bit of therefore, a back channel to President Truman. And they went to see him and said, we've lost 6 million to the Nazis in World War II, but there are some Jews still alive in Europe who are desperate to leave and get to Palestine. They're held in these DP, displaced person camps. The British are not letting them in. They're clinging to this 75,000 quota. They're saying only a couple of thousand more can come. Can you please put pressure on Britain to allow at least, say, 100,000 more Jews into the country? And so the President, Truman, asked the dean of the law school at the University of Pennsylvania, Earl Harrison, who you see here, asked Dean Harrison to go to Europe and make an inspection tour of the DP camps. And in late July of 1945, Harrison sent a 10-page, single-spaced typewritten memo to the president with this language here, which completely shocked President Truman when Harrison said, "We, the US Army, appear to be treating the Jews as the Nazis treated them, except we do not exterminate them." The next day, Truman publicly called upon now Prime Minister Attlee, Clement Attlee, to open the gates of Palestine to at least 100,000 Jewish Holocaust survivors. So how did the British government respond? Foreign Secretary, now Ernest Bevin, proposed what? Another commission. Let's get 6 American judges and lawyers and 6 British judges and lawyers, maybe a couple of non-lawyers are okay too. Let's send them to Palestine and Europe and America and England and hear testimony from witnesses and conduct a trial. And so the Americans agreed. The 2 co-chairs were eminent judges. This is Sir John Singleton of the King's Bench Division in London, known as a very difficult judge, very, very hard on lawyers and witnesses, had written a pamphlet a few years earlier called Conduct at the Bar. A very hard-nosed judge. He was one of the co-chairs. The other co-chair was this person here, Joseph C. Hutchison Jr., the Chief Judge of the United States Court of Appeals for the Fifth Circuit in Houston, Texas. He had written a very interesting law review article in the Cornell Law Journal in 1928. It's my favorite law review article of all time, and I've read a lot of them. The title of the article is "The Judgment Intuitive, the Role of the Hunch in Judicial Decision-Making." When he kind of confessed, yeah, we read the briefs and we listen to the lawyers, but I wait for that gut feeling in my belly to tell me which way to rule. A wonderful article. So he was the other co-chair. This is James McDonald, future first ever United States ambassador to Israel, head of the War Refugee Board in World War II, very sympathetic to Zionism, very important role he played in the founding of Israel. This is Richard Crossman, the youngest member of the committee, an avowed socialist, member of the British Parliament, ardent anti-Semite and anti-Zionist, until one night in Rehovot, he went to Chaim Weizmann's house for dinner, came home the next morning, wrote in his diary, which I found in the archives at the University of Coventry, and said, "What an amazing dinner. I'm now totally committed to Zionism." If anybody can guess who's in this picture, you get not full extra credit, but some extra credit. Who's on the left? Oh, come on. Who's the lady on the left? That's Rita Hayworth. And her lawyer, Bartley Crum from San Francisco, California. Bartley Crum was a member of the committee. He was a celebrity lawyer. Rita Hayworth was one of his clients. Crum remembered for heading an organization called Republicans for Roosevelt in the 1944 election campaign. Here's the committee photographed together at their first meeting in Washington, D.C. You see the 2 co-chairs in the center at the bottom and the other members. They held their first round of hearings in the State Department conference room in Washington, D.C. This photo is from the cover of my book. I absolutely love this photo because you see the 12 members arrayed around this U-shaped table and the witness in the middle being grilled by Justice Singleton, Judge Hutchison, and the others. The first set of hearings were in Washington, D.C. Look who testified. Einstein testified, very critical of the British handling of Palestine, but not so bullish on statehood for the Jews. He would have preferred sort of a one state for everybody, why can't we all just get along type of thing. You get really super extra credit if you know who this is. The committee moved to London, big hint. Anybody been to Tel Aviv? Who's driven along the beach in Tel Aviv where all the hotels are? What's the name of the street? The big boulevard that goes, Sir Herbert Samuel. This is Herbert Samuel, who became the first ever British ambassador to Palestine during the Mandate in the 1920s, a Jew. accused by the Jews of not being Zionist enough, accused by the Arabs of being a spy for the Jews. You could imagine what a difficult job. He testified in London, and then the committee went to Jerusalem. Have any of you been to the old train station in Jerusalem? You recognize the sign there? You see Yerushalayim at the bottom. The committee took the overnight train from Cairo, where they took some testimony. Wouldn't it be great if you could go by train nowadays from Cairo to Jerusalem? In those days, you could. And in Jerusalem, the committee began by touring the holy sites, the Wailing Wall, the Dome of the Rock. And you see them here. Anybody know where they were staying? What hotel were they staying? King David, very good. And they're walking across the street. Here are the two chairs, Singleton and Hutchison. They're walking across the street to conduct their trial. To what building? What's across the street from the King David? YMCA. The YMCA. And at the YMCA, they heard testimony from a large number of witnesses, the most famed witnesses on both sides. This is Chaim Weizmann testifying. Here's Ben Gurion testifying. Jamal Husseini, I showed you his picture earlier, the Mufti's cousin, testifying. There's his lawyer, Auni Bey Abdul Khadi. He also testified as a witness. This is Mordechai Eliash, the president of the Palestinian Jewish Bar Association in Jerusalem. Remember, before 1948, the Jews were also Palestinians. If you're a lawyer in Jerusalem, you're not Israeli, you're a Palestinian Jewish lawyer in those days. He testified. Okay, really super duper extra credit if you can identify either of these two gentlemen. Anybody? Well, here's a big hint. The one in the center there, leaning over with the glasses, that's Judah Magnus, or Judah Magnus, the first chancellor of the Hebrew University of Jerusalem, another native of San Francisco, California, by the way. And sitting next to him is Martin Buber. And like Einstein had done in Washington, the two of them argued to the committee in their testimony, no state for the Jews, no state for, let's just make it one kumbaya kind of place. And the committee back then said, love the idealism, totally impractical. And this is important because we're seeing a revival of this today. There are Jews and a couple of Palestinians who are proposing this kind of version of the one state idea today. I think it remains as impractical now as it was then, unfortunately. Goldie Meyerson, AKA Golda Meir, testified. This is Henry Katan, another famous Palestinian lawyer. He testified. Albert Hourani, famous Arab professor at Oxford, testified. This is the original founder of the PLO. Arafat was not the founder of the PLO. He came 3 years later. This is Ahmed Shukeri, also a lawyer, founder of the PLO in May of 1964. We'll come back to him in a few minutes. And he testified in the committee hearings in 1946. And here is the Mufti, Haj Amin al-Husseini. We've seen his cousin Jamal. We've heard about the Mufti. Here he is. Did he testify? No. Why not? Because he spent the war years in Berlin, canoodling with Hitler, broadcasting radio messages to the Bosnian Muslims, asking them to fight alongside the Nazis. And when the war ended, the British government issued a warrant for his arrest. He was a wanted war criminal. He was in French custody, somehow miraculously managed to escape and made his way to Cairo. The Mufti was persona non grata in British eyes. They would not let him testify. Well, after weeks of testimony in 1946, the 6 Americans and 6 British lawyers and judges and others were hopelessly divided, couldn't agree on anything in terms of rendering a verdict. And so they decided, we need to go to a quiet place to see if we can reach some kind of compromise. So they selected the 1-star Beau Rivage Hotel in Lausanne, Switzerland. They spent 3.5 weeks there in March of 1946. And it was at that time that the American judge, Judge Hutchison, received a telegram from President Truman. President Truman said, I am very hopeful that you will be able to reach a unanimous verdict. Very important that the United States and Britain speak with one voice. And Judge Hutchison wrote what those of you who are maybe lawyers would recognize as a tentative ruling, wrote a draft of the verdict, and then convinced Crossman, the one that had dinner with Weizmann, to put pressure on the other members of the British delegation to come up with a unanimous verdict after 3.5 weeks. It was really kind of, I would say, a miracle that they were able to agree on anything. And to celebrate really his victory here, Judge Hutchison threw a dinner for the members of the committee the night before they announced their verdict publicly. I found the menu for that dinner in Judge Hutchison's papers buried in the archives at the University of Texas. Judge Hutchison, an alum of UT Law School. And if you look here on the right, you see all the members of the committee sign their names. Here are Judge Hutchison's initials. This was his menu, JCH, Joseph C. Hutchison Jr. A very whimsical menu he came up with the chef at the Beau Rivage. You see Jewish or Arab grapefruit, Balfour soup, potage Balfour, tourne de truma aux champignons bevin, apples, Texas-style apples, because the judge was from Texas, a Café Haganah, and the wine, Chateau Nuftu Mufti. Wonderful, wonderful find. And here's the verdict of the Anglo-American Committee. First of all, they decided, you know what, even though we don't like this kumbaya deal, we need the United States or Britain to stay there and keep order. So no state for the Jews, no state for the Arabs, number one. Aha, but number two, the British White Paper of May 1939, the one that restricted Jewish immigration and cut off Jewish land acquisition, was against international law. It violated those provisions of the Palestine Mandate I showed you earlier. Really amazing for 6 British commissioners to agree. And moreover, President Truman is right. Those 100,000 Jewish Holocaust survivors should be allowed into Palestine. Britain, do what you can, open the gates, help them get there. The British government was furious at those 6 Britons who were on this committee, absolutely enraged. And so what did Foreign Minister Bevan and Prime Minister Attlee decide to propose to Truman? Another committee. And so here you have on the left, Henry Grady, a State Department official, nice guy. And on the right, the Home Secretary of the United Kingdom, Lord Herbert Morrison. Now, just looking at this picture, who do you think got the better of the other in the negotiation? Grady had no chance. He went to London, Morrison took him out for dinner, entertained him, and within short order, Grady agreed to a Canadian-style solution on the right. The green would be kind of a Jewish province, think of Quebec. The yellow would be an Arab province, think of Saskatchewan. And Britain would keep the areas in pink, that same area that we saw in the original 2-state solution between Jaffa and Jerusalem and Bethlehem, plus the Negev, but all of it would be under British control. This was called the Provincial Autonomy Plan. Truman was not happy with Grady for agreeing to this. The plan went nowhere because neither the Jews nor the Arabs liked it. And so by the time we get to early 1947, the British government had had enough with Palestine. Enough already. We've been there 25 years since the 1922 mandate. We've had nothing but trouble from the Arabs and the Jews. And so Britain turned to the brand new United Nations formed after World War II and said, you deal with it. We have enough problems on our own hands. We just emerged from World War II. We're depleted financially. We're depleted in terms of our military. We still have India to worry about. Britain is still in India then, not for much longer, but still in India. So the United Nations willingly took over the Palestine file and did what? Held 2 more trials in 1947. The first under the United Nations Special Committee on Palestine, UNSCOP, UNSCOP, chaired by who? Another judge, Emil Sandstrom on the right there from Sweden, stacked with lawyers like Enrique Fabregat from Uruguay. Here's Judge Ivan Rand from Canada, Chief Justice of the Canadian Supreme Court on the committee. Jorge Garcia Granados, a lawyer and diplomat from Guatemala, wrote a great book, by the way, about his experience on UNSCOP. By far the single most supportive of the Jews of any member on the UN Special Committee, by far. Amazing person. His granddaughter, by the way, lives in Tel Aviv today. Anybody know who this is? Come on. Ralph Bunche. Excellent. Ralph Bunche was the um, #1 staffer to the UN Special Committee. He actually wrote the majority report recommending the two-state solution. The committee, just as that Anglo-American committee had done, conducted their trial in the summer of 1947 at the YMCA building in Jerusalem. You needed a ticket like this to get in. Who testified? Well, there's Chaim Weizmann again, but who's this behind him? Abba Eban, then Aubrey Eban from South Africa, later Israel's first ever ambassador to the UN. Ben Gurion testifying. If you were a witness looking at the members of the committee, this would be your view. Note, all the way on the right there, Iran, a member of the committee, but very different from the Iran of today. The last person you see on the left is actually Garcia Granados from Guatemala. The angle is a little bit tricky. The delegate from India you can't see. He was actually from Lahore, Pakistan, a judge. He was the most anti-Semitic and anti-Zionist member of the committee. So the committee could not achieve unanimity, but they did achieve a clear majority. The king of Jordan, Abdullah, no, this is Abdullah I, son of the Sharif Hussein of Mecca, great-grandfather of the current king of Jordan, Abdullah II. The committee went to visit him in Amman and interviewed him. At the same time, he was telling the committee, no state for the Jews. He was secretly meeting with Golda Meir, negotiating a similar outcome. The Mufti had him assassinated outside the Al-Aqsa Mosque, going in for Friday prayers in July of 1951, with his grandson, the future King Hussein, at his side. This, therefore, led the deliberations of the UN Special Committee, and their majority decision led to yet another trial conducted by a larger committee called the General Assembly Ad Hoc Committee for Palestine, chaired by yet another judge, Judge Herbert Evatt from Australia. And after months of trials and hearings in the summer and fall of 1947, both the Special Committee and the Ad Hoc Committee came up with the same verdict, namely the two-state solution. One state for the Jews, one state for the Arabs, going back to that kind of British concept from 10 years earlier in 1937. Jerusalem would remain a separate body, a corpus separatum in Latin, an international zone, all of Jerusalem, west, east, and the Old City. The Jews were thrilled with this outcome. Wasn't clear until the actual UN vote on November 29, 1947, whether the necessary two-thirds majority could be mustered to support this. The Jews were thrilled. The Mufti, still in charge of the Palestinians, rejected, renounced the two-state solution, and immediately launched a civil war against the Jews in Palestine. Just to rack up our maps again, here's that 1937 solution, two-state solution, which you remember. There's that provincial plan in the middle, and note how the UN took the provincial plan's green area, grafted it onto their two-state solution, but then gave most of the Negev to the Jews. That's basically how the map was created. And so you see the orange for the Jews, the yellow for the Arabs. Note how much larger the yellow is than the modern day West Bank. The Arabs could have had a much bigger state if they had only said yes to the UN offer of the two-state solution in November of 1947. This is the General Assembly at their old headquarters, original headquarters in Lake Success, New York, adopting the two-state solution. The New York Times the next day reporting by a margin of 33-13, the Arabs walked out. And note, just as the British like to do, the UN appointed another commission to go to Palestine to figure out how to implement the two-state solution. But the commission couldn't go, it was too dangerous. The Mufti was killing as many Jews and British soldiers as he possibly could. And of course, the Jews were fighting back. I want to be fair. The Jews were also killing British soldiers. It was too dangerous for the UN to go there. And so the Palestine Commission sent this report in February of 1948, a couple of months later, to the Security Council, saying something that you would never in a million years see from the United Nations of 2023. What'd they say? Powerful Arab interests, both inside and outside Palestine, are defying the resolution of the General Assembly and are engaged in a deliberate effort to alter by force the settlement envisaged therein. Do you think the UN today would ever say anything like that? It was a very different UN in those days. I bring you to May 14th, 1948, Friday afternoon. So before Shabbat, Ben-Gurion, if you've been to the building, it's now known as Independence Hall. It used to be called the Tel Aviv Museum of Art. Ben-Gurion read the Declaration of Independence. Then night came, Shabbat came, and at midnight, the British Army lowered the Union Jack for the last time and left Palestine. And the next morning, the Egyptian Air Force bombed Tel Aviv. And the armies of Lebanon, Syria, Iraq, Jordan, Saudi Arabia, and Egypt all invaded simultaneously, with the Palestinians inside the country also fighting. And if you just take a second to think about this, we lost 6 million in the Holocaust. We had nothing. How did we win this war? 1956 and 67, 73, we had an army and an air force. We had nothing. And this was truly the miracle of the creation of Israel, that this war was won. And when the war ended, I'll come to you in 1 second. When the war ended, and by the way, this is a map from the Truman Library, President Truman's papers, but True Confessions, it's on Wikipedia if you want to take a look at it. The areas in pink on this map are additional areas that the Israeli army captured in the 1948-1949 war. Areas that the UN had allocated for the Arab state now came under Israeli control. And that led to the modern day map of Israel that you see on the far right. But the Palestinians today do not lay claim to those areas that were captured. Some do, of small minority, but the focus is on the West Bank. So let me just wrap up this presentation very quickly with my own view of what the legal consequences of this history are. Why are they relevant for today? And I won't read this word for word, but essentially my argument is that when the Palestinians rejected every offer of statehood that came their way, in 1937, in 1939, in 1947 twice, and ever since, by the way, in negotiations with Ehud Barak and with Prime Minister Olmert, those multiple decades-long rejections of offers of statehood give rise legally to the concept of waiver. Implicitly, to be sure, but waiver. The Palestinians made those implicit rejections of statehood explicit on two occasions. First, in December of 1948, 3,000 Palestinian notables gathered in Jericho, passed unanimously a series of resolutions asking King Abdullah, you saw him earlier, to bring them into Jordan as Jordanian citizens, to annex the West Bank, to make it part of Jordan. And the king did that. Between 1948 and 1967, the West Bank was part of Jordan. In May of 1964, during the Jordanian occupation, I showed you Ahmed Shukeri, the founder of the PLO. The first PLO meeting, conference, Congress, was held at the Intercontinental Hotel in East Jerusalem, the Jordanian part of Jerusalem, on May 28, 29, 1964. And those gathered passed a resolution adopting the original version of the PLO charter. And I point you to Article 24 of the original PLO charter, which says, the PLO does not exercise any regional sovereignty over the West Bank in the Hashemite Kingdom of Jordan or the Gaza Strip, which makes sense because the Palestine that the Palestine Liberation Organization wanted to liberate was not the West Bank or Gaza. It was what? The state of Israel. It was only after the Six-Day War that their position changed. And if you don't believe me, let me refer you to this document, which I found in the archives in London. This is my second to last slide. A confidential report from the British ambassador in Amman to the Foreign Office in London, February 1964, noting what? Ahmed Shukeri has been in Amman on his Palestine entity mission. His first statement on arriving in Amman was that there was no question of creating a Palestinian Republic, as this would be meaningless? Or was there any intention of attempting to create or establish a form of Palestinian territorial sovereignty? He added, I'm at the bottom now, he added that the creation of a Palestine government was not desirable as it would not serve the Palestine cause. The PLO was created purely as a fundraising vehicle and a terror organization. And then I would bring you to the Oslo Accords, the Declaration of Principles in September of 1993, the interim agreements 2 years later in 1995, where Arafat negotiated and signed his name to a document saying what? Saying, we agree that the occupation can continue until such time as we have a final deal. We agree the settlements can stay there until such time as there's a final deal. And we agree that in the meantime, we'll take control of our major towns, Ramallah, Hebron, Bethlehem, Nablus. That's called Area A for Arab, if you will. We'll share control over the smaller towns with the Israelis, that's Area B. And the remaining part, 60% or so, where the settlements are and where the Israeli army is, will remain under Israeli control. This was not imposed on Arafat. He negotiated and voluntarily signed the Oslo Accords. And so I'll end with the photos of my two book covers. Thank you so much for having me. And I'd love to take questions. I just skipped over you. I'd love to hear a question. I'll repeat the questions for those on Zoom. If there are Zoom questions, I'd love to take those too. And then when we get through this, I can spend a few minutes with your permission on the current situation with the Israeli Supreme Court. So thank you for inviting me.
Was there any doubt that Truman would agree with recognizing the state of Israel?
There were very powerful voices in the
Please
US
repeat the
Department.
question.
Sorry, was there any doubt, excuse me, was there any doubt the question was whether Truman would recognize the state of Israel is the question. And the State Department, the Bureau of Near Eastern Affairs at the time, headed by Assistant Secretary of State Loy Henderson, was violently opposed to Truman's plan to recognize Israel. The State Department fought tooth and nail, almost succeeded. At the last minute, and Truman, by the way, was fed up with the State Department, but he was equally fed up with the lobbying from every Jewish organization you can imagine. He only wanted to talk to Chaim Weizmann, nobody else. And he told his friend Eddie Jacobson, if any more Jews from other groups come here, Israel's done, forget it. He was furious. And it was at the end, a meeting between Weizmann and Truman that convinced Truman to go ahead with the recognition. Truman interlineated the word in his own handwriting, provisional, but it was still recognition, and Truman did it 10 minutes after Ben-Gurion read the Declaration of Independence. Really remarkable. Yes?
What did Secretary of State George C. Marshall advised Truman strongly not to recognize.
So was the Secretary of State George C. Marshall at the time? Yes. Did Marshall advise Truman not to recognize Israel? Also yes, because he had the State Department bureaucracy feeding their recommendations to him. And Marshall also thought that the Zionists were communists. And there, of course, was a very strong socialist bent in the Yishuv. And Marshall was very concerned about a future state of Israel becoming a Soviet beachhead in the Middle East. Interesting the way it eventually worked out with Egypt and Syria becoming Soviet clients, but that was Marshall's worry at the time. Yeah, sorry, go ahead, Bruce.
You didn't describe any great love between the British government in the late 1930s and Jews. Can you give us just some idea of the degree of the population of Jews in Britain at the time, their political influence, and what kind of anti-Semitism was?
So the question is about Britain's less than sympathetic stance toward the Zionists and the Jews in the late 1930s. What about the British population? Did they have much to say about this? The British Jews in the UK were very divided about Zionism. At the time of the Balfour Declaration, there were some very, very, very prominent British Jews who were adamantly opposed to the Balfour Declaration because they thought it would jeopardize their elite status in British society. Very kind of selfish, inward-looking stance. In hindsight, I can say that. It's hard for me to be critical of them at the time. You know, we have a lot of Jews in this country who are very iffy now about Israel. And I don't want to say that they're cowardly or anything like that. It would be grossly unfair for me to say that. But it does remind me a lot what we see in the American Jewish community today, what we saw in the British Jewish community during the time of the Balfour Declaration and the war. Now, to take it to the 1930s, there were still at that time many powerful British Jews who were against Zionism for still the same reasons. They thought the Zionists were troublemakers, they were socialists, maybe also say that there were other British Jews, Rufus Isaacs, aka Lord Reading or Reading, who devoted every penny, every shilling they had to the cause of Zionism, and others in Britain as well who were absolute heroes. Weizmann based himself in London. The Zionist organization was based in London at the time, and he had enormous support from some very, very courageous and influential British Jews. So the British Jewish community was divided, unfortunately, the way the American Jews are today.
So the way PLO enters into agreements, it assumes that the Arab political organization is monolithic. How do we know that all that population accepts PLO as the leading as the organization? I know they had elections and everything, but there's a widespread population that that may not accept that they're shot if they're thought to be sympathetic. I mean, how can we say that your logic about the waivers is legitimate if some people say, I don't accept PLO as my representative?
Great question. The question is to the extent that I am ascribing to the PLO responsibility for Oslo or to prior Palestinian rulers for refusing offers of statehood, is it fair to ascribe the same view to other Palestinians who may have disagreed with their leadership but been afraid to do so for fear of a retaliation? And I would say,
Considering that you say that it only formed in 1964, and you're saying this is ongoing since like 1928.
yeah. So the follow-up was, I'm saying this is true since 1964, but this has been going on since the PLO's formation, but it goes on for years before then. So when the Mufti was the leader of the Palestinians, there was an organization, the predecessor of the PLO government, and the League of Nations recognized as the sole legitimate representative of the Arabs in Palestine, and the Mufti is their legitimate leader. There were no elections. It was actually Herbert Samuel, the Jewish ambassador to Palestine, who gave the Mufti his job. He was on the government payroll. But legally, he had authority to speak for the Palestinians. And so, you know, President Biden speaks for Americans. And even though I may disagree with his policies in certain parts of the world, he speaks for the United States. Just as the PLO has been recognized by the United Nations, the Arab League, and even the United States government as the sole legitimate representative of the Palestinian people. So as a legal matter, they have authority to bind their people. Yeah.
I have a question.
Yes, Bruce. Bruce has a question. Go ahead.
A while back, I gave a presentation about Islam, and Islamic law came up, specifically the Taqiyya, Baya, which in the first instance, it is stated that it's okay to lie to people in order to gain things for Islam, and the treaty verified it because they did that against, I forgot the name of the city, but they, within a 10-year period, they broke the treaty within 3 years for a minor disagreement. So how does this type of a logic tie into international law that we have right now?
Okay, so you all heard the question. There is this argument that's made that Islam inherently permits deceit, deception, lying if it is in the service of Islam. Look, I'm not naive, but many countries violate their agreements. President Obama spied on Angela Merkel, for crying out loud. You know, we have countries and organizations will ultimately pursue their own national interest. Treaties play an important role in international law. And, you know, one of the arguments on the Israeli right is, and even the Israeli left, by the way, is, can we trust the Palestinians to comply with their obligations, their treaty obligations, if we do make a deal? They violated Oslo left and right. We withdrew from Gaza and they thank us by firing missiles at us. So what level of confidence can we have that they'll keep their promises, especially when they can invoke a Quranic justification for breaching their promises? And that really comes down to the issue of enforcement. It comes down to the issue of enforcement. And if the Israeli government believes that there is an effective way to achieve enforcement of any agreement with the Palestinians, either militarily or financially or technologically, then I'm sure that whether it's a left-wing government or a right-wing government, they would move forward, but not without that confidence that the agreement can be enforced.
I have more of a public history question.
Why don't you come up and say your question in the microphone so they can hear you?
Sure, yeah. I was saying I have more of a public history question. I was just curious what classes you're teaching on campus and what type of students that's attracting, and if you feel like you're having productive debate or what's coming out of these classes.
So I do not teach any classes on this. Can you hear?
Couldn't hear her.
Okay.
She's talking to the mic, but not
Okay,
to us.
sorry. So the question is, what classes do I teach at UCLA and UCSB, and how do students react? I don't teach classes on this subject. Unfortunately, and we see this even more so at UCI, very anti-Israel sentiment on campus. But I do manage to sneak in some of this in some of my classes here and there. And I must tell you that the Palestinian students appreciate it when I bring this history to light. They really appreciate it because they never heard about it before. And I show documents. I have given you some of my opinions here, but I try to be very factual and kind of neutral, and the Palestinian students really appreciate it. I teach other courses on other subjects. I think none of which would be of interest here, but I don't teach in this area.
Steve has said that he will be happy to talk about the judicial issues happening in Israel right now, but I want to take one little break and mention that we do have copies of his book here. Jerry went out of the way to get them for us, and if you do want a copy, talk to Jerry after the meeting and you can pick up one. And so let you continue on with your talk.
I think I see there's one question on chat.
No, that the thing on chat is, it says, "Thank you very much for the talk." I read it.
Any other questions about this? Otherwise, I can talk about the Supreme Court if you'd like, very quickly. Okay, why don't we do that? I'll bring up my other presentation, which is here. And we'll put it. Whoop. Okay, good. Everybody see this? Where's this picture? Tel Aviv, a couple of months ago. On a Saturday night, every Saturday night since January, people have been out in their tens and hundreds of thousands protesting a package of proposals that the government, the new, very right-wing government, most right-wing in the country's history, is trying to push through to change in a very dramatic way the role of the Israeli Supreme Court in the country's democracy. So we'll talk about that a little bit. By the way, can you read? I know it's very, very small. On the right, the English sign says "must resist," and the sign in the center there says "from startup nation to shutdown nation." Very, very ominous kind of warning from at least these people in Tel Aviv. So why are they protesting? The new government, I mentioned, elected in November of last year, has a thin majority. And you all know that in Israel, you do not vote for a person, you vote for a party. And in order to form a government, a party or a group of parties in a coalition have to command 61 a simple majority of the 120 seats in the Knesset. This new government, comprised of the Likud and some very far right-wing parties, has 64. So a majority, fairly thin but somewhat firm majority in place. The members, the most right-wing members of the new Israeli government, you've heard about Itamar Ben-Gvir and Mr. Smotrich. They have argued for a long time, for years, that the Israeli Supreme Court is too left-wing and keeps getting in the way of legitimate policies that the elected representatives of the people sitting in the parliament and the Knesset want to move forward. And so the solution is to weaken the power of the Supreme Court. In fact, the solution has three legs to it, three parts to it. One, let's make the Supreme Court weaker, make it harder for the court to overturn laws passed by the Knesset, as it has done on 22 occasions since 1995. Second, on the flip side, let's make the Knesset stronger. Let's make it easier for the Knesset to overturn legislatively Supreme Court decisions which it disagrees. Meaning, if we get a simple majority of 61 votes, we can overturn any Supreme Court decision that we don't like. Well, they have 64. If you only need 61, you pretty much give the Knesset full power to strike down any bad Supreme Court decision. Now, there are people in this country who would love it if the US Congress could, by a simple majority, overrule the Supreme Court on Citizens United, or overrule the Supreme Court decision last June, Dobbs versus Jackson Women's Health Center, that struck down, that reversed Roe versus Wade. So this idea of the elected representatives being the last word, there's a lot of people in this country who are saying the same thing. And that's what the right wing in Israel is saying regarding the power of the Knesset. And then the third way, so weaken the Supreme Court, strengthen the Knesset, and the third leg of the stool is to change the way that members of the Israeli Supreme Court are selected. Unlike here, Supreme Court, all federal judges serve for life. And so we have to wait for someone to die or to resign for a Supreme Court vacancy to come up. And the president nominates, the Senate has a confirmation hearing and a vote. Israel is different. Israel does not have life tenure. You serve until age 70, and then it's mandatory retirement. We have 9 on our Supreme Court, they have 15. So vacancies come up a lot more often there than they do here. And to fill a vacancy in Israel, there's a special process which the new government wants to change that would essentially allow the new government to put anybody they want on that court. The mailman, the dog catcher, anybody they want, they can put on that court. So let's take a closer look at each of these three. First of all, in terms of weakening the Supreme, and I won't go through all this in detail, some of it is quite technical, but in terms of weakening the Supreme Court, first thing to remember is that Israel, unlike America, does not have a constitution. When the country was formed in 1948, remember, as I said before, too much else to deal with. Multiple Arab armies attacking, the country fighting for its survival. Ben-Gurion and the religious people agreed to disagree and not try to write a constitution, but instead to kind of develop a constitution over time through a series of laws called basic laws that don't require any special majority, nothing different than regular laws, but a basic law would be a law that would articulate a core concept, a core value of the state of Israel. The most recent basic law is the law from a couple of years ago that declares Israel to be a Jewish state, which offended Israel's non-Jewish citizens. Another basic law is the 1980 basic law declaring Jerusalem united, East, West, and Old City, to be the capital of the country. There are other basic laws proclaiming human dignity to be a fundamental value of the country. So the right wing wants to weaken the Supreme Court by making it almost impossible for the court to overturn regular laws and make it nearly impossible for the court to overturn a regular law that contradicts a basic law unless you get a supermajority of 12 out of 15 members of the court. The court ordinarily sits in groups of 3. And right now the court is mostly left wing. If the government is able to stack the court with their judges, they'd be able to prevent the Supreme Court from striking down any laws passed by the Knesset. All they need is 3 or 4 out of 15 to block the other 9. How about making the Knesset stronger? The proposals would allow a simple majority of 61 to overturn any Supreme Court decision they want. The opposition leader, Benny Gantz, has said, well, we get your point, but it shouldn't be a simple majority because that would allow the new government to strike down any Supreme Court ruling they want. Let's make it a supermajority of 80, 2/3. If 80 members of the Knesset go along, then yes, the Knesset can overturn a Supreme Court ruling. And right now, as we saw before Passover, when Netanyahu kind of took his foot off the gas to leave some space for negotiation, the ceremonial president of the country, Isaac Herzog, has been meeting with both sides, trying to broker a compromise. This is one area where there is I think, a very good likelihood of compromise. What about the third issue? Picking members of the Supreme Court. Again, I won't go through this. Essentially, the current system has a judicial selection committee of 9 people. So we don't have, Senate confirmation hearings like we do here. We have a selection committee, 9 people. It requires 7 out of 9 votes to put somebody on the Supreme Court. No single block on this committee commands 7 votes, which means what? Which means you have to compromise. The Supreme Court has a couple of votes on the committee, the party in power, the opposition parties, and the Israel Bar Association sits on the committee. Last year, under the prior government, Yair Lapid, a Muslim Arab was put on the Supreme Court as a compromise candidate. What does the new right-wing government want to do? They want to make it easier for them to have an automatic ability to put anybody they want by requiring only a simple majority of 5 out of 9 and by having 5 people from the government on the committee. So you might be thinking, well, okay, Trump did that with Amy Coney Barrett and Brett Kavanaugh and Neil Gorsuch with complicity from Mitch McConnell and the Senate Republicans. Imagine if we did have that system here, though. The president can put anybody they want on the Supreme Court without the Senate having to hold a hearing. That's what this would be. And I think that is really the most dangerous part of these proposals. What about Bibi Netanyahu, who is on trial right now for corruption? By the way, you might ask me, why does the right wing want to weaken the Supreme Court so much? Why? It's actually quite simple. Smotrich and Ben-Gvir for years have been saying Judea and Samaria, the West Bank, belong to us. Read the book of Genesis. Every important episode in the book of Genesis takes place in the West Bank, not at the beach in Tel Aviv. We want the West Bank. The Supreme Court, though, is too independent, too left-wing. They're going to get in our way. And so we need to weaken that court. That's their motivation. They want annexation without judicial pushback. What does Netanyahu want? He wants immunity. And so it's in his interest also to weaken the Supreme Court and give the Knesset power to give him immunity. Now, to be fair, as I said before, and a federal judge once said this to me. He was actually quite angry. I thought he was being nice, but he told me later he was furious with me. He said, Mr. Zipperstein, even the thinnest pancake has 2 sides. When I was getting a little bit Kenyan, a little overzealous about something. And there are 2 sides to this pancake. The Supreme Court of Israel has been an activist court since 1995. It has struck down a number of Knesset laws based on the court's view that the laws are unreasonable. What does that mean? Again, you don't have a constitution. And so there is a view that the Supreme Court does need to be reined in a little bit. Not as much as we're talking about here, of course. And that's why the opposition is willing to negotiate over how many votes would it take for the Knesset to be able to overturn the Supreme Court. 61 or 80 or somewhere in between. We'll have to see how that works out. But for me, the bottom line, and this is why everyone has been protesting so much, these proposals, if they end up going through in their present form, would change Israeli democracy forever. An independent judiciary is the linchpin to any democracy. It certainly is in this country. It's the one thing that saves us from the tyranny of the majority. And absent a strong, independent Israeli Supreme Court, the right wing, the religious parties will have their way and turn the country into a theocracy and take it away from democracy. That's just my own personal view, but that's why I think this is so dangerous and so worth our attention. Finally, Bruce, if you'll permit me, I'll come to you in 1 second. I just wanted to mention what is going on right now. I referred to it at the very beginning this morning at the International Court of Justice based in The Hague in the Netherlands, and also the International Criminal Court. Last December, the UN General Assembly passed this resolution. It's very lengthy. I've just given you the most important provisions, basically saying Israel is a criminal. So what are the legal consequences of the fact that Israel is a criminal nation? And the court has asked for briefs to be filed. Only countries are allowed to file briefs under the court's rules, but the court has already said the Palestinian Authority, the PA, which is not a country, can file a brief. The Organization for Islamic Cooperation, which is not a country, can file a brief. And the Arab League, which is not a country, can file a brief. Would the JCC in Orange County, California, be given permission to file a brief? Absolutely not. The court is going to render an adverse decision against Israel probably around a year from now. It's an advisory ruling, non-binding, but it will have a very, very bad impact on Israel's global standing. It will reinvigorate BDS here at UCI and on my campuses at UCLA and UCSB and around the country. It could have consequences for Israel's membership in the UN, God forbid. It could have consequences for Israel's access to the international global financial system, God forbid. Very, very serious. The International Court of Justice previously, 19 years ago, issued a ruling, another advisory ruling, saying that the wall of separation or the separation barrier is illegal. And the Palestinians sued the United States at the court in 2018, complaining about the move of the embassy from Tel Aviv to West Jerusalem. The court has not yet issued a ruling in that case. And at the International Criminal Court, which again only has jurisdiction over referrals from countries, from states, the court has accepted a referral from the Palestinian Authority, granting it statehood status. And the court is now investigating whether individual Israelis have committed grave breaches of international law in Gaza, in the West Bank, and in East Jerusalem. And we have to keep a close eye there as well. That will also have very, very severe consequences. So that's my last point. I'd love to take more questions. Again, thank you, Bruce.
I just have one question on the judicial area. I sat, this past Shabbos, I sat after it was out in the Kiddush, and I sat with a number of people, and their biggest thing, we had a discussion on the judicial, their biggest thing was the unreasonableness. They felt that the Supreme Court, they are just on a whim, could say, okay, fine, this law is unreasonable and therefore it's not good. I also read one point, and I'm not really clear on this, but for example, when the IDF went in and they destroyed a terrorist house, the Supreme Court ruled against it or something. So I think that this is the leftist point that these people are and one other thing, they were talking about the interns for the Supreme Court justices and their family members, and they felt that it's all intertwined, and that was their main. Okay. I mean, they were really vehement about it.
So the question refers to a prior speaker at a synagogue who was giving kind of the right-wing argument for reforming the Supreme Court. The Supreme Court has struck down Knesset laws as unreasonable, and that seems to be a flimsy kind of a standard, pretty much whatever the court wants to do. The court has prevented the government from destroying the homes of terrorists, which, by the way, was authorized under British law during the mandate. The legal advisors to the justices sometimes are family members of those justices, and there's a little bit too much insularity, we can say. Well, it's called nepotism too at the court. So here are my responses. In American law, we have a concept that comes from a law called the Administrative Procedure Act. It's the concept of what we call arbitrary and capricious rulemaking. And the Supreme Court has struck down many times rules that come from federal administrative agencies as violating this notion of arbitrariness and caprice, which is very ill-defined as well. We also have a concept under Fourth Amendment law in the criminal realm, where the Fourth Amendment prohibits unreasonable searches and seizures. And the Supreme Court has struggled for 200 odd years to come to grips with the meaning of the word reasonable in the Fourth Amendment. The court has said that searches without a warrant are presumptively unreasonable, but then the court goes on to list like 15 or 20 exceptions to the warrant requirement, meaning it's completely reasonable for the NYPD to walk up to a black person on Fifth Avenue and throw them up against the wall and pat down their outer clothing for weapons or contraband under a Supreme Court ruling from 1968 called Terry against Ohio. And all the officer has to say in court is, well, based on my experience, I thought that there might be criminal activity afoot. The person was walking up and down, looking through the windows of Tiffany's. And unlike Audrey Hepburn, didn't have a cup of coffee and a donut. So, you know, we have similar kinds of issues in American law, and the unreasonableness rulings of the Israeli Supreme Court are actually very well reasoned. In terms of house demolitions, yes, the court has blocked the army, not every time. In fact, the small minority of the time. The court also, in a case called Alfei Menashe, issued a week before that 2004 International Court of Justice case. The Supreme Court of Israel ordered Prime Minister Ariel Sharon to move 6 portions of the wall that encroached on Palestinian land. Sharon said, oh, that's ridiculous, but I will obey the court. We're a democracy, and I will obey. On the issue of the legal advisors and the nepotism, yes, that's a problem. Has it had a substantive impact on the rulings themselves? Have those legal advisors, not members of the court, not judges, behind the scenes caused the court to do things it shouldn't have done? I don't think so. The US Supreme Court, each member of the Supreme Court has 4 law clerks. One of them, we think, might have leaked the draft ruling last year overturning Roe v. Wade. I don't think it was a clerk. I think it was actually one of the judges that did it. Or maybe Putin hacked into the Supreme Court's computer. Who knows? But law clerks at the Supreme Court are very powerful. They help the court decide among the thousands of petitions given to the court every year. The court only takes about 100 cases. And the clerks play a very big role in deciding, helping the judges decide which cases to take and which to reject. So again, you know, we have a similar situation here. Nepotism, yeah, there are judges in this country, not so much at the Supreme Court, but in the lower courts, who hire clerks very nepotistically. And I know that, I know that to be a fact all over the country.
We have a constitution here.
Yes.
Ultimately, Supreme Court rules on the Constitution. We may not agree with what they say, whatever, but if we had no Constitution and we had 9 judges up there saying, well, listen, I think it's really unreasonable to do this law, and we're going to throw it out. I think we would have a revolution here.
So the follow-up question was, we have a constitution here, and the Supreme Court has the ultimate power. Actually, the Constitution doesn't give the Supreme Court the ultimate power. Chief Justice Marshall, much like Chief Justice Aharon Barak did for the Israeli Supreme Court in 1995, Chief Justice Marshall in 1803 in Marbury versus Madison said, we are arrogating unto ourselves the power to strike down any act of Congress that violates our Constitution. Article 3 doesn't give the court explicitly that power. So it's worked for us more or less. It'd be great if Israel could have a constitution too that would clearly delineate the relative roles as to each other of the three branches. But what are the odds of even two Jews agreeing on one constitution?
So, the International Court case where it said Israel's on trial for a crime of denying statehood to Palestinians. But if we vacated Gaza and allowed whatever authority to take over, and then Hamas instead took over, how are we kept an agreement to allow territory to be declared a state. And how is that? I mean, where is the evidence and grounds that Israel has done this?
So how can the International Court of Justice fault Israel when Israel withdrew voluntarily from Gaza and then Hamas took over? And why is that, rather than the PLO, why is that Israel's fault? There are today at least two Israeli law professors, of whom I'm aware, maybe more, who maintain, these are Israelis, who maintain that Gaza is still occupied as a matter of international law. Why? Because Israel controls the ocean, and Israel controls the air above Gaza. And so Gaza technically is still under occupation, even though there has not been one Israeli soldier, other than briefly during wars, on Gazan soil since the disengagement in September of 2005, and not one Israeli settler since September of 2005. I disagree with the argument.
Even if that small portion is occupied, the rest could have been under Arab state progression.
The rest could have been under Arab state progression of Gaza, you mean?
Yes.
Yeah, even if a small portion is occupied. Gaza is an extremely tiny area. When Israel withdrew in 2005, pursuant to a deal with Arafat called the Gaza-Jericho Agreement, which was part of the overall Oslo package, the full expectation, and this goes back to our question about can we trust the Palestinians to keep their word, the Israelis withdrew, and less than a year later, in June 2006, Hamas launched a war against the PLO in Gaza. And I'm going to be a little graphic here, forgive me. Many PLO officials were thrown off the tops of buildings by Hamas and drowned in the ocean. It was brutal, it was bloody, it was violent, and Hamas has ruled Gaza ever since. Is that Israel's fault? Is Hamas the world's largest open-air prison, as the Norwegian Organization for Human Rights maintains? Or is Gaza the world's largest terrorist base, as I maintain?
Thank you for this very concise and comprehensive review of stuff I've forgotten. But my question is, it seems like most of the world is against Israel, but has there been a warming up of relations with the Arab world and Israel, the Abraham Accords, and I think there have been some interaction between Israel and Saudi Arabia. And I've always been led to believe that the Arab world thinks that the Palestinians are troublemakers and don't like them. So could you enlighten me on that a little bit?
Yes. The question is, what is the situation with Israel's relations with the Arab world and more broadly? Whereas we used to say in Hebrew, Ha'olam kulam negdenu, the whole world is against us. We now see things changing a little bit. Of course, the Abraham Accords were a huge, huge game changer in the region. Morocco always had very powerful ties with Israel because there was a huge outflux of Moroccan Jews to Israel in 1949, 50, 51, many of whom go back and forth. Bahrain, very unexpected. US Navy base in Bahrain. The United Arab Emirates, no real surprise there. Dubai had invited the Israelis to participate in the World Judo Federation tournament a few years earlier. And then Sudan, of course, now going through a horrific humanitarian situation, an extremely bloody civil war Biden just evacuated the US Embassy in Khartoum over the weekend. Very awful what's going on in Sudan. And so, yes, for many, many decades, all of those Arab countries said, we will not have anything to do with Israel, except for Egypt and Jordan, which were military adversaries and negotiated peace treaties. We won't have anything to do with Israel until you give the Palestinians their statehood first. That was always referred to as the inside-out paradigm. And some Israeli, very clever Israelis, began arguing 20 years ago, well, why don't we flip it and make it outside in? If some of the peripheral Arab countries normalize relations with us, that will show the Palestinians that, there's something to be gained here. Maybe they're not going to wait for you. Maybe it's in your interest to go back to Oslo and negotiate a little bit more. And that outside-in paradigm has begun, obtained a lot of momentum with the Abraham Accords of June of 2019, not 2020. And unfortunately, we've seen progress stall. Relations between Israel and the UAE are very good. But if you look at the air travel back and forth, every plane from Tel Aviv to Dubai is full with Israelis. Every plane from Dubai to Tel Aviv is also full with Israelis. There are no Emiratis coming, none. And that's a little bit concerning. And during the World Cup, of course, in Doha, Qatar is funding Hamas, and Qatar agreed to allow Israelis in, but they were really harassed at the World Cup in Doha. Oman, very moderate Arab country, opened their airspace to Israeli overflights, which makes the trip now from Tel Aviv to the Far East a lot easier. Saudi Arabia has opened its airspace to Israeli overflights. I once flew from Tel Aviv to Mumbai. We had to go up and then all the way down the Red Sea and all the way up the other side. Now you can go straight across and save 2 hours of flying time. But, there's been a bad development recently. China brokered a rapprochement between Saudi Arabia and Iran. And I don't think that we're going to see any meaningful progress on the Saudi track. There's, of course, lots of sub rosa, under the radar stuff between Saudis and Israelis, but overtly, very little, and very little chance of it going forward. I don't see any chance of any kind of breakthrough with, maybe Djibouti and some other lesser countries, not to be offending to Djibouti, but I don't see anything big emerging with any other Algeria or anybody else in the near future. This International Court of Justice case is really dangerous in that regard as well. Very, very dangerous. Yep.
Martin, you always ask about the two-state solution. Do you ever believe there's going to be a two-state solution for our friend Martin here?
Do I ever believe there will be a two-state solution? Hope springs eternal. I do think it is the fairest solution. Part of my argument, which I sort of presented to you today without kind of saying it in so many words, is that again, personal view, I do think the Palestinians have a political and moral claim to statehood, but they've abandoned politics. They embarked on a political track in Oslo. Arafat negotiated and signed his name to the agreements, and they've abandoned politics and instead chosen to put all their eggs in the legal basket, bringing these cases at the International Criminal Court and the International Court of Justice. And that's why I've written these books, because I think it's fair to ask, okay, if you're pursuing litigation and not negotiation, how strong is your case? Just how strong is your legal case? And I think their legal case is pretty darn weak. Whereas I think their political case has much more oomph to it. And I wish they would come back to the table and focus on statecraft and negotiation and not litigation. So look, the real answer to the question, though, depends upon the successor to the current Palestinian leader, Mahmoud Abbas, Abu Mazen, who is in year 19 of a 4-year term, pushing 90. Maybe he's even older than 90. We don't know exactly how old he is. I know a lot of sprightly 90-year-olds up in Santa Barbara where I live, but it'd be a good idea if he were to appoint a successor. Supposed to be elected, but if he names a successor, that person will win, because then we'll know. Will we have someone that we can talk to, or will we have somebody who will keep with the terrorism? And I will tell you, in my work at UCLA and the Center for Middle East Development there, where I meet overseas regularly with people from the Palestinian Authority, there are a lot who want a deal, a lot. They're sincere. They're from a new generation. They want commerce and technology and trade. They want their families to have a better life. And they want a deal. And then there are others who are just like the Mufti, all or nothing, all or nothing. From the river to the sea, Palestine will be free. You see that, though, much more at UC Irvine than you do from people who actually live there. Much more prominent here than there. So I am cautiously optimistic, depending on who succeeds Abbas.
Can you comment briefly on the possibility of a return to the Iran nuclear deal?
Can I comment briefly on the possibility of return to the Iran nuclear deal? Well, we have a new regime in Iran, which is as far to the right as the Israeli regime is, the Israeli government is, although worse, because I don't hear the Israeli government saying they want to destroy Iran. They just want to stop the Iranian nuclear program. But we hear Iran every day vowing to destroy Israel. I think that the JCPOA that the Obama administration negotiated with Iran was a huge mistake for the United States. For one thing, it was not a treaty. Obama did not bring it to the US Senate for a vote because he knew he didn't have enough votes to get it ratified, even from within his own party. Senator Bob Menendez from New Jersey, Democrat, was adamantly opposed to the deal. What did the deal do? The worst part for me was not giving the $200 billion to Iran or easing off on saying, that wasn't the worst part. The worst part was the deal had a sunset clause. After 10 years, the deal went away. The deal was 2015. Under the terms of the deal, Iran could resume nuclear production, nuclear weapons production in 2025. And that to me was an unconscionable concession by the Obama White House, by then Secretary John Kerry. I also don't agree with Trump pulling the US out of the deal. It would have been much better for Trump to renegotiate, to use leverage to renegotiate and obtain a much, much, much longer time horizon, if not in perpetuity, for the ban on nuclear weapons.